Welcome to Corporations. I'm Professor Seth Orenberg. In corporations, we study a number of topics ranging from introduction to corporations through the duties that directors hold. This chapter pertains to the fiduciary duties of directors. The fiduciary duties of directors are duties that are owed to the shareholders of the corporation. We've already learned about corporate agency, applying agency law specifically to the corporate context. And we discussed the duty of care, which discusses the business judgment rule, a doctrine of abstention, where judges will not review board decisions that are made with paper and process. Now we're going to address the duty of oversight, sometimes known as Caremark duties. The board has two primary functions. One is to make decisions, and two is to oversee the corporation's business and to prevent it from getting into trouble. We've already explored board decision-making and talked about how the business judgment rule applies to affirmative actions by a board in certain contexts. Now we're going to discuss when a board has an affirmative obligation to act and where an omission to act can create liability for those directors. Directors' functions can then be grouped into two general categories: decision-making, which, when made for a business judgment, can be held to the duty of care standard, and duty of loyalty comes into play because if a corporation's directors act when they have a personal interest, they may violate their duty of loyalty to the business. The duty of oversight kind of pertains to both of these categories, sometimes categorized as care claims. If a corporation's board is not diligently overseeing the company, they may not be fulfilling their duty of care. Other times, since duty of care claims are essentially non-starters for reasons we'll re-examine in just a moment, they're characterized as duty of loyalty breaches. Whether you see them as duty of care or duty of loyalty, we still have some fundamental principles to establish about when a corporation's board has a duty to perform certain actions and the omission of those actions can result in liability. Let's first return to the business judgment rule. The business judgment rule pertains to the duty of care. The duty of care says that a corporation's directors must take care when making business decisions, and their decisions, when done with certain paper and process, is going to be protected from review by courts. Unless a director has a conflict of interest, most of their decisions that were made with enough time to think about them and the right process and the right information will not result in liability to a director. Courts will not award liability. And this is even more true when the board of directors is protected by an exculpation clause. After the famous Van Gorkum case, the Delaware General Assembly established Section 102B7 of Delaware General Corporation Law. The MBCA, Model Business Corporations Act, has a similar provision that allows the directors to be exculpated for any breach of the duty of care. Now, this exculpation provision does not include any bad faith actions, any improper distributions to shareholders, or, of course, any breach of the duty of loyalty. The reason that this was done was because we want directors to take risks, and after the Van Gorkum case, boards were a little more trepidatious about making decisions. But this is a bit of a different duty. This is not about taking risks. This is about a board's obligation to mitigate certain risks that would be unfortunate for the company. Not business risks, but legal risks, other type of risks that you would not want to happen in a corporation, such as the employees bribing foreign officials and the company coming under scrutiny for Foreign Corrupt Practices Act. For the reason that this is about compliance with the law and risk management to an extent, this is sometimes referred to as a duty of obedience, saying that the board has an obligation to fulfill the law. This is quite disputed at this point in corporate law. Although it's recognized that nonprofit directors have a duty of obedience, many corporate scholars will not go so far as to characterize a board's obligation as to have a duty of obedience to all laws. And as you can imagine, it would be very difficult for a corporation to make sure all its employees were obeying all the laws all the time and to have board liability if they were not. For example, if Waymo is developing self-driving cars and one of its engineers develops a car that exceeds the speed limit in certain instances, is that a violation of the fiduciary duty of directors? It seems hard to imagine that it should go that far up the chain. Likewise, we might consider if there is a separate duty of good faith. Now, we know that good faith is implied in all contracts, and directors are employed by corporations by virtue of contract and agency law. And in corporate law, good faith is also implied, but it's not considered a separate duty. As we'll see, good faith is an element of all of the duty of care, the duty of oversight, and the duty of loyalty. Let's take a look at a case law that gives us an insight into some of the early formations of this law. In Francis versus United Jersey Bank, a 1981 decision, there was a closely held corporation that acted as a reinsurance broker. Pritchard and Baird, a reinsurance broker, had 4 directors, and they were also the only shareholders. They were named Charles Sr., Charles Jr., William, and Mrs. Pritchard. That was the wife of Charles Sr. Charles Sr. passed away, and Mrs. Pritchard apparently became an alcoholic after this, and quite frankly didn't take much of an interest in the company before, but certainly not afterwards. Meanwhile, during his life, Charles Sr., and after his death, his children, Charles Jr. and William, were taking money from corporate accounts. They were essentially taking shareholder loans at a time when the business didn't have the money to do this. And although Ms. Pritchard was a director of the company, she took no interest in what was going on. The company went bankrupt, and the trustee in bankruptcy, that's in this case United Jersey Bank, sued Miss Pritchard's executress named Frances. So this is really a case against Pritchard. That is the woman who was a director and was completely asleep at the switch. She was an alcoholic. She never showed up to a meeting. She never reviewed the minutes. And now she's represented by her executress, Frances, which is a stand-in for Pritchard. And on the other side of the V, we have United Jersey Bank, which is the trustee in bankruptcy, representing the claimants that are now at a loss for funds because Miss Pritchard had failed in her duties as a director. This is the classic example of a failure of oversight. We have an individual on the board who is doing nothing to make sure the company is going smoothly. The proverbial asleep at the switch director who is not even present at the meetings, who is not reviewing any of the minutes, who didn't even look at the accounting statements. And if she had looked at those accounting statements, it seems like she would have known something was going wrong. Well, what exactly was going wrong? Pritchard and Baird was a reinsurance broker, and so they were a fiduciary to a number of funds for insurance companies. They had access to a lot of cash. And this was supposed to be segregated, but instead of keeping it segregated, Ms. Pritchard's children, Charles Jr. and William, were using this as their personal piggy bank. The company was giving shareholder loans out of the trustee accounts. This is clearly a violation in many regards, but what is Ms. Pritchard's responsibility for this violation when the company goes bankrupt? That's the question here. Well, this is the easy case. This is the case where it's obvious that there is a breach of the duty of oversight, and this one's formulated as a duty of care breach here. Ms. Pritchard never made the slightest effort to discharge any of her duties. Now, what's a little unusual about characterizing this as a care claim is duty of care claims are usually about making a bad decision. But here, this was not about a commission, not about a decision. This was an omission, a failure to do something in light of a duty to act. This was characterized as a breach of the duty of care, although it was really about her omission from showing up at all. She didn't take care in not going to the meetings. It's not clear whether or not this is better characterized as a care or an oversight claim, but the important thing here is that there is a breach of her fiduciary duties because she was asleep at the switch. Had she paid any attention at all, she would have known her sons were misappropriating funds. The New Jersey Supreme Court rejected the executress's argument that Ms. Pritchard was a quote-unquote simple housewife and a quote-unquote grief-stricken drunk. She could have stopped this. In fact, she should have stopped this. And what we learned from this is courts will evaluate directors not subjectively based on their abilities, but how a reasonable director in like circumstances should act. Not how this director in these circumstances did act, but how a reasonable director of reasonable competence should act. The fact that Miss Pritchard was inherently incompetent was no excuse in this case. The New Jersey Supreme Court concluded that Pritchard's neglect of duty contributed to the climate of corruption. Her failure to act contributed to the continuation of that corruption. Consequently, her conduct was a substantial factor contributing to the loss. Sometimes, the court said, a director may have a duty to take reasonable means to prevent illegal conduct by co-directors. In an appropriate case, this may include threat of suit. And yes, that means the court said Ms. Pritchard should have threatened to sue her children. The court reviewed things that a director should do. The director should be familiar with the fundamentals of the business, have a rudimentary understanding about how it operates and what it does. A director has a continuing obligation to keep informed about the activities of the corporation. A director cannot be a sentinel asleep at the post. This only means a general monitoring is required. This is not a detailed inspection of day-to-day activities. We're not checking all the employees' fingernails to make sure that they're clipped and that their beds are made. We're just having dashboards and operating systems in place to make sure that any malfeasance is reported. Of course, regular attendance at board meetings is central to a director's obligation, and then if a problem does present itself, a director has a duty to either object to the problem, resign, or sue. Now, what did Ms. Pritchard do? Well, she was drunk, incompetent, lackadaisical, unconcerned. She made no efforts whatsoever. She does not get the benefit of the business judgment rule, where her unjustifiable non-efforts are what caused the harm. And speaking of cause, that's an element of these claims. And unfortunately, if you read the Francis v. United Jersey Bank carefully, it doesn't really address causation. We actually need to show that Pritchard's irresponsibility caused the harm. Now, the court in this case kind of skips that step. Maybe it's obvious, but it's an important analytical step for you to apply when doing your evaluation of whether a director is fulfilling their duty of oversight. Here are the key takeaways from Francis. Directors should attend board meetings. They must stay informed about the company. Their job is to set corporate policy and strategy, hire, fire, and pay executives, and importantly for the duty of oversight, monitor the business. Monitor it for illegality and misconduct especially. Illegality and misconduct, that's not business risk, that's legal risk. This isn't a decision. This is a failure to watch out and be a watchdog for the sake of the shareholders. This is a sentinel asleep at the post, a director asleep at the switch, and therefore a breach of the duty of oversight. A director would have inquired and objected, should have inquired and objected after realizing what was going on, and occasionally a director has to step up and when the executives are not performing, manage the business in a crisis. Now, let's say Ms. Pritchard was not an accountant, and you might not be one either. Take a look at this chart and see if you can identify the problem here. Well, let's take a look. In every year from 1970 to 1975, the company is losing money. They lose more and more money every year. In every year since 1973, their income goes down. Meanwhile, shareholder loans are increasing remarkably. By 1975, the company is loaning $10 million to shareholders, the children, the directors. If Miss Pritchard took a single glance at this sheet and saw that her children were borrowing $10 million and more from a company earning $500,000, it would be obvious that something foul was afoot. With these kind of financials, a director has an obligation to act. Of course, the court still should identify that failing to act caused the harm to the trustee. That wasn't shown in this case and is an element of the duty of oversight. That's not to say that directors have to go that far beyond this to avoid liability. In fact, the Model Business Corporations Act differentiates between standards of conduct and standards of liability. In a way, the standards of conduct are somewhat aspirational. The standards of conduct say that each director should always act in the best interest of the corporation, always become informed, and fulfill their oversight function with zeal. This is the duty of attention, but it's not a very strong duty. In fact, we have a separate standard of liability. A director is only liable, is only going to be sued successfully when there is a sustained and systematic failure to devote attention. There's a clear difference between devoting attention on a regular basis and a sustained and systematic failure to provide that attention. Many scholars have then questioned whether or not the standard of conduct for directors is real or merely aspirational. Professor Mel Eisenberg said that a standard of conduct is how you should play a role. A standard of liability is when a court will find judgment against you. And in the real world, these can be very, very different. But in the case of Francis v. United Jersey Bank, Ms. Pritchard was clearly in violation of her duty of oversight. She failed her standard of conduct and her standard of liability by being totally asleep at the switch, a sentinel asleep at the post, not performing the obligations required of any director. What about that argument she made that she was a quote-unquote mere housewife? What qualifications must a director have? Who can be a director? It turns out that a qualification for a director is not very onerous. A director must be a natural person. And if you're wondering why, read Todd Henderson's excellent article, Boards Are Us, which contemplates corporations acting as directors for corporations. Other than being a natural person, there really isn't much required. The director does not have to own stock in a corporation and does not have to have any special expertise, although a director should become familiar with the business, and a director on a public company audit committee should be a financial expert. Whatever that means. Not clear. Should there be more qualifications? Maybe. Maybe we should include more, but we're allowing shareholders to pick their directors. And that's part of the private ordering in corporations. Moreover, it wasn't Ms. Pritchard's lack of expertise that caused the problem. It was her complete failure to become informed. She was asleep at the switch. In the case of Barnes v. Andrews, Judge Learned Hand discussed what qualifications a director must have. I will quote him. He says it better himself. Talking about a passive director, the defendant, Andrews, in Barnes v. Andrews, Judge Learned Hand says, "True, he was not very suited for the job, but I cannot hold him on that account. After all, it is the corporation that chose him and now seeks to charge him. Must a director guarantee his judgment is good? Directors are not specialists like lawyers or doctors. They are general advisors of the business, and if they faithfully give such ability as they have to their charger, it would not be lawful to hold them liable. A director does not have to guarantee his judgment is good. And a shareholder can call them to task by voting them out of office. And so we do not evaluate directors based on whether they are good or bad, but they need to show up for work. And being asleep at the switch clearly violates the duty of oversight, as Judge Learned Hand points out. Let's move into oversight of the modern corporation. And one of the seminal cases here is Graham versus Allis-Chalmers Manufacturing, a Delaware case from 1963. This case held that directors only need to respond to red flags. And I have a red flag for you. This is not good law. This is no longer the law. This is a story in the evolution of the law, but this is not good corporate law today. However, it begins our discussion of internal controls, which we'll see has been continuing and has implications for some statutes like Sarbanes-Oxley. In this case, a derivative action was brought against the directors of a multi-division manufacturing firm with over 31,000 employees. The company and 4 non-director employees were indicted for federal antitrust law violations of price fixing. The suit claimed that the directors had no knowledge, but should have had a system in place to bring misconduct like price fixing of employees to their attention. The complaint alleged director malfeasance. But what malfeasance? A failure to institute a monitoring system that would raise red flags. The board did not have any indicia of malfeasance. They did not know their employees were behaving badly. The plaintiff here is arguing that the board should have had a system in place, a system of raising red flags to determine malfeasance in advance, and could be liable for a failure to have these monitoring systems in place. Now again, this case is no longer good law. This is not the state of affairs today. And in this case, the issue was whether the directors breached their fiduciary duty by failing to institute a monitoring system. And the court held no. This is not the law today, but in 1963, the Delaware court held that there was no breach of the duty of oversight because a board of directors does not need to establish a quote-unquote corporate system of espionage to ferret out wrongdoing. There was nothing to put the board on notice, and so they were not liable for the actions of the employees where they had no reason to know of that. Again, not good law today, as we will see in Caremark, but at this point, the court is thinking the directors do not have an obligation to ferret out wrongdoing. The court found the directors are entitled to rely on the honesty of subordinates and felt that it would be espionage to spy on the employees to make sure they were not violating the law. I'll quote the court briefly. Absent cause for suspicion, there is no duty upon the directors to install and operate a corporate system of espionage to ferret out wrongdoing which they have no reason to suspect exists. Only if he has recklessly reposed confidence in an obviously untrustworthy employee or has ignored obvious danger signals. That was the law in 1963. It is not the law today. The law changed dramatically, and the corporate world was shook to its core by the holding in In re Caremark International, Inc. derivative litigation, a Delaware case in 1996 that really changed the idea that directors did have to ferret out wrongdoing. And here is the beginning of case law saying that we need internal controls. And of course now, Sarbanes-Oxley and other statutes require by statute that corporate directors have these internal controls. We have a somewhat similar structure here. Like the antitrust violations in Graham, here the plaintiff alleged that the Caremark Board of Directors breached their fiduciary duty of care by failing to have an oversight program where the employees gave kickbacks to healthcare providers. These kickbacks, just like bribes or price fixing, are illegal. And the company agreed to pay $250 million as a result of these kickbacks. Should the board have had a monitoring system to make sure employees were not giving kickbacks to healthcare providers in order to sell their pharmaceuticals? Should the board have had a monitoring system in place to make sure that employees were complying with the law? Did the board have a duty of oversight with regard to legal risk? That's the issue in this case. To put it another way, the issue is whether the board was likely to have breached its fiduciary duty of care by allowing or not preventing employees from violating law and getting the corporation indicted. And the court recognizes that this is the most difficult theory in corporate law upon which a plaintiff might hope to win a judgment. The claim is that directors allowed a situation to develop which exposed the corporation to liability. This is a duty of care breach under this standard. By the way, why did I say likely to win? The issue is a matter of procedural posture. This had to do with the procedural posture that this was a motion to approve a settlement. Those details are less important here because the main finding of the court was that while there was merely a low probability of a duty of care breach, unlike Graham, there was a possibility that duty of care was breached here, where the Caremark management did not have an appropriate system of oversight to prevent its employees from engaging in kickbacks. Under Delaware law, to this point, if there is a good faith effort of the board to be informed, the business judgment rule applies. Does not create liability for a bad decision, so long as the board is trying to stay informed. In this respect, the court did not see a breach of the duty to make a decision in good faith. There was no decision to which you could attach liability. The only reason for assigning liability then was a failure to monitor, an omission, not a commission, not a failure to make a good decision, but a failure to make a decision at all, a failure of omission, not commission. That's the duty of oversight, where the board has not done something it ought to do. The court stated there must be an oversight plan in place. This essentially added a third element, a third way for directors to be liable. Directors can be liable for breach of the duty of loyalty when they are self-dealing, when they are paying themselves out of the corporation's pockets. They can be liable for a breach of the duty of care by negligent board decisions, really grossly negligent board decisions. And now they can also be liable under the duty of oversight for an unconsidered failure to act. That failure, of course, has to result in loss to the corporation. Is this a new duty? Is this a duty of attention? Does this say the board has to be paying attention to everything that's going on? Well, I don't think it's that broad. The court seemed to say that if the board makes a good faith effort to be informed, that will be enough. But here, the court found there was at least a possibility that the board had not made sufficient effort to become informed and prevent this bad outcome. But this does mean there is a new type of liability for boards, a liability for failure to monitor, not attached to a specific decision. A specific decision, that's a duty of care issue. Did the board take care? Did they have paper and process in rendering a decision? This is a failure, an omission, a failure to make an oversight plan, not a failure in its execution. This has created a whole new breed of Caremark duties. Under Caremark, it seems that plaintiffs would have to show that the directors knew or should have known because they failed to implement some monitoring system that would have given them information, that systematic and sustained violations of the law were occurring, that the plaintiffs showed there were no good faith efforts taken by the directors to remedy this violation. And then it goes to the directors. They have the burden at that point to prove that their failure did not proximately cause the losses complained of. These Caremark duties really extend the amount of liability a board can have. So while Van Gorkum extended that in the duty of care and exculpation in 102b7 limited it, now we see again an extension of liability to directors, not for commissions, not for decisions, but for omissions, for failure to have oversight. Because if a director should have known, if a system in place would have told directors that a violation of law was sustained and systematic and occurring at the company, and there was a lack of steps to take remedying that, well, then the directors can be liable for a failure of their duty of oversight. In other words, a Caremark duty is a duty to attempt in good faith to assure that a corporate information and reporting system exists. It has to both exist and be adequate. It can't just exist and be crap. Failure to have a functional system of reporting can, in theory, render directors liable for legal violations and maybe other violations that occur because, and again, that causation is important, because this oversight failure resulted in harm to the company. Now boards are more focused on becoming reasonably informed. They have to assure themselves that monitoring systems exist and the system has to work. Note how much farther this goes than the Francis case. In Francis, we have a director asleep at the switch, not attending at all. Here, we're going a bit farther and putting an affirmative duty on the director to ferret out wrongdoing. Not the same as Francis. These directors were showing up at meetings, doing their obligations, but they didn't have something in place to make sure there weren't kickbacks happening. As a result, they're found potentially liable. Caremark really changed the landscape and required directors to put in more oversight provisions than they'd ever had before. In Graham v. Allis-Chalmers, the court ruled that absent cause for suspicion, there is no duty to install and operate a quote-unquote corporate system of espionage to quote-unquote ferret out wrongdoing. But in Caremark, which went much farther, it requires reporting systems exist that reasonably provide important information to the board that they can make informed judgments about legal risks. And it provides potential for oversight liability. Failure of the duty of oversight can result in liability when directors fail to act in good faith in implementing these systems. Other laws have imposed additional requirements on management to have internal controls. Sarbanes-Oxley, which responded to Enron and WorldCom, heightened levels of disclosures public companies had to provide and required internal and external controls to make sure the disclosures were truthful. This was a response to those accounting disasters in Enron and WorldCom. Section 404 of the Sarbanes-Oxley Act of 2002 requires management to assess internal controls and to provide an internal control report, which states the responsibility of management for creating these controls and assessing their effectiveness. Again, going back to the principle that a board of directors, per Caremark, must both establish internal controls and feel confident that they are working. This standard was put to the test in Stone v. Ritter, a 2006 case in Delaware. This involved AmSouth Bank. AmSouth Bank, like all banks, is required to file a suspicious activity report when certain transactions occur. AmSouth failed to file a suspicious activity report, even though it probably should have, and as a result, a Ponzi scheme was run through the bank. And Louis Hamrick and Victor Nance stole a huge amount of money from the American public through this awful Ponzi scheme that AmSouth potentially could have prevented if they had filed this report and shut down that account. The United States government sued AmSouth and said that AmSouth lacked a compliance program and adequate board oversight of it. The directors didn't see any red flags. Are they liable for these harms? Shareholders Stones filed a derivative action against the parent company. And the plaintiffs, they acknowledged there were no red flags, but they said the directors, quote, utterly failed to implement any sort of statutorily required monitoring, reporting, or information controls that would have enabled them to learn of problems requiring their attention. Do you think that the plaintiffs will win on this claim? Do they have to make a pre-suit demand on the board, or will they be able to simply force the corporation to sue its directors because of this quote-unquote utter failure? The court dismissed the claim. This is a Caremark claim, but demand is required. Why? The directors here did set up systems. They had a system that in fact was approved by an independent auditor. There wasn't a total lack of process. It simply was that the process, with 20/20 hindsight, did not work. The court found the directors did not act in bad faith. They made an impartial decision to put controls in place. They put controls in place. They got a report from an auditor that the controls were good and effective. They did not know that the controls were bad. There was a bad outcome, but a bad outcome does not mean there was bad faith. We need bad faith here. We need to actually show the directors did not try. They might try and make a mistake. When directors try and make a mistake, that's a breach of their duty of care. But the duty of care is protected by the business judgment rule, and here it was a business decision as to what types of systems to implement. The duty of care requires that boards make informed decisions and oversee the corporation. And in this case, the duty of oversight claim was framed as an aspect of the duty of care. Since there was a bad outcome, the plaintiff argued, there must have been a breach of the duty of care, but it doesn't work that way. Hindsight is 20/20, and we give directors some laterality about this. In fact, that's what we put them in place to do. Delving briefly into the procedural posture, this was about whether or not pre-suit demand was excused. Pre-suit demand was not excused because there was no possibility of personal liability, so the directors could have, in effect, been willing to sue themselves since they would not have been found personally liable. This leads us to the rule from Stone. When directors fail to act in the face of a known duty to act, thereby demonstrating a conscious disregard for their responsibilities, they breach their duty of loyalty by failing to discharge that fiduciary duty in good faith. But that didn't happen here. What do we need to show in order for a plaintiff to win? A failure to act in the face of a known duty to act, meaning an utter failure to implement any reporting controls, but here there were controls, or having implemented a system, an utter failure to monitor them, deliberately looking the other way. We have to essentially show that the directors acted in bad faith or failed to act in good faith, violated their duty of loyalty because they were truly asleep at the switch. Now we start to see that Francis conversation framed as a duty of loyalty claim. Not surprising, since this is after Van Gorkum, and many companies now have exculpation clauses that make duty of care claims non-starters. In fact, AmSouth had such an exculpation clause, so they had to frame this as duty of loyalty. They can only show demand is futile if the directors could be personally liable. They can't show that here, so the court dismisses the case. So what's the rule? The rule today is that in order for a board of directors to be liable for a failure of oversight, they have to have an utter failure to implement controls or turn a blind eye to the result of those controls. That didn't happen in Stone. AmSouth had compliance systems. They didn't work, but that's okay. No, we need to find an utter failure. That means the plaintiffs have to show the directors failed to act in good faith. That would create a duty of loyalty violation. Otherwise, the exculpation clause basically precludes duty of care claims. The only way you get to a breach of the duty of loyalty, that's an utter failure for the directors to do their job. The plaintiff would have to prove to sustain a violation of the duty of loyalty that the directors knew or should have known that laws were violated due to a sustained and systematic failure of oversight, and the directors took no step to remedy the problem, and the failure was a proximate cause of the loss to the shareholders. And so we see that Caremark duties seem to be more about the duty of loyalty, because directors have to avoid them removing themselves from the circle of information. Part of their loyalty to the corporation is spending their time and attention on it. I suppose the thinking here is that the directors could be vacationing in the Bahamas or doing anything else as opposed to paying attention to the corporation. And if they're doing something enriching themselves at the expense of the corporation, that's a breach of the duty of loyalty. In any event, what do we need to look for one of these claims to prevail? We need an utter failure of oversight. That means a failure to implement systems or a failure to actually pay attention to them. This is directly related to the concept of risk management. Now, businesses have lots of types of risk. They can have business risk, credit risk, project risk, technological risk, IP risk, legal risk. So risk management is a major aspect of corporate behavior, and only some of those risks pertain to the duty of oversight. Some of them pertain to the duty of care. Businesses take business risk, and the duty of care and the business judgment rule states that the duty of care is not going to be challenged where a director is making an informed business judgment. We're going to look at this in some of the early financial cases to see how that plays out. In Citigroup shareholder derivative litigation took place in the midst of the 2008 financial meltdown. In fact, this case was decided in 2009. And this case is about whether or not directors can be held liable for failure to monitor and police for financial risks. There are numerous cases in which directors are blamed for oversight failures, but what about failures to monitor for subprime risk? Is that a type of risk that we're going to hold directors accountable for outside of the business judgment rule? A breach of the duty of loyalty? Well, the situation was that Citigroup held billions of dollars of CDO squareds, and these investments, well, let's just say they didn't go very well. For those of you who have lived through that crisis, it's called the subprime mortgage crisis. These CDO squareds were these collateralized debt obligations built out of a bunch of subprime, low-quality mortgages, and based on some complicated math that some physicists at MIT cooked up, they were supposed to be very low risk, and they turned out to be horribly risky because their risks were correlated with each other, and as one started to fail, they all started to fall. We ended up in basically the Great Recession. And you know what happens when companies take a nosedive like this? Well, unsurprisingly, shareholders are going to sue the directors. And what do they sue them for? Breach of fiduciary duty, violation of their duty to monitor and oversee the company from these type of problems in the subprime market, ignoring the red flags that these CDO squared investments are terrible investments and should be gotten rid of. And so they allege demand futility, saying the board would be liable, so they would not sue themselves, and so we can sue them directly. How do you think this case came out? Are the shareholders going to be able to have an oversight claim for failure to monitor credit risk of CDO squared? No, demand is not excused. This is not really an oversight case. This is about duty of care. Monitoring risk is Citigroup's business. They make investments. The allegation is that the board sat by and, in fact, preferred what turned out to be bad investments. You don't get to sue the board for making a bad business decision. That's what you put them in place for. It doesn't make sense to sue the person that you hired for doing a bad job at the job you're paying them for. Board liability comes from two places. Either a reasonable but wrong or negligent decision. Those are protected by the business judgment rule. So as long as they are business decisions, a failure to monitor, that requires an unconsidered failure where there is loss stemming from it. An utter failure to set up control systems or an utter failure to monitor them. The board could have been liable if they knew they weren't discharging fiduciary obligations or if they were demonstrating a conscious disregard for those obligations in the face of a known duty to act, like red flags, but they knew that there was risk in this business. They decided to enter it anyway. Shareholders don't get to sue directors for taking business risks that don't pan out. Hindsight is always 20/20. It is never the fact that when a company takes on business risk and suffers losses, even catastrophic losses, that itself is evidence of misconduct, and without more, therefore, a basis for director liability. There were signs in the market, the court ruled, that reflected worsening conditions and suggested that conditions may deteriorate even further. But that's not an invitation for the court to disregard the presumption of the business judgment rule and conclude that the directors are liable because they did not properly evaluate risk. The plaintiffs in Citigroup were asking the court to conclude from the presence of these red flags that the directors failed to see the extent of Citigroup's business risk and therefore made a wrong decision by allowing Citigroup to be exposed to the subprime mortgage crisis. Failure to make a good business decision, I'm sorry, shareholders, that's protected by the business judgment rule. Corporations are designed to take risk. Shareholders, you should mitigate against that risk by diversifying your investment. And if you don't like it, vote the directors out. Overseeing risk is difficult. You don't know when the next storm is coming. Just because you are inundated by a problem does not mean the directors are going to be liable. That's not how corporations work. We are monitoring for a failure of oversight, for a lack of attention, for being asleep at the switch. But disasters happen, and the result of disasters is not that we get to sue our corporations. In fact, the opposite is true. The business judgment rule protects against that. Businesses are permitted, in fact, encouraged to take risks, and disasters do happen. It is only when those disasters and their harms are the result of an obvious, utter failure of the board to implement monitoring systems and to control for them that we're going to find liability. Thanks for listening. Again, the main points of this chapter that you should be able to now address are what are the functions and qualifications of directors. While the qualifications are minimal, showing up at board meetings, making affirmative decisions, and implementing certain oversight to protect against illegality by employees, for example, are part of the director's functions. A corporate director has done too little when they're asleep at the switch, see Francis, but also when they have utterly failed to implement monitoring systems or pay attention to them. Breaches of the duty of care are hard to prove because the business judgment rule precludes a lot of action against them. So these cases of oversight have been categorized more and more as breaches of the duty of loyalty. It's not entirely clear how those are distinguished, but it is clear that being asleep at the switch is not only a breach of care, but of loyalty if one is doing something else instead of their job. The duty of obedience, to a certain extent, may explain this because there does seem to be a growing interest in corporations abiding by the law, and these oversight provisions are generally going to be held where a corporation has violated the law because an oversight regime is not in place that would have prevented that. And for the attorneys in the room, you must know that you have a duty to report suspected malfeasance. Those financials in Francis v. New Jersey Bank were really problematic. Clearly, shareholders should not be lending themselves $10 million when a corporation is losing money at a similar rate and only earning $500,000 a year. Even the most junior associate on the case has an obligation to report when there is an evidence of corporate malfeasance. Thanks for joining me. Next, we'll review duties of loyalty and talk about how judges will consider conflict of interest transactions.